So good afternoon or morning, everyone. Welcome to the webinar, which is called Getting Ready for Opt-outs. We're actually waiting a little bit for some more participants to join us. In the meanwhile, I can already tell you what is on the screen on your slide for the moment. So all your microphones will be muted or are muted and your cameras are switched off. If you have any questions that you would like to pose during the webinar, we would please ask you to pose your questions in the Q&A part, which you will find below on your screen. Our speakers will then answer your questions shortly. We will do this either during the live session or in a private reply later on. So I'm just waiting a few seconds still for participants to join. So welcome everyone. If some people would have joined in the meanwhile, we have some more participants. So once again, we are getting ready now to start the webinar. I welcome you all. And your microphones are muted, your cameras are switched off automatically. And if you have any questions, please post them in the Q&A button, which you will find below on your screen. And we will answer the questions during the Q&A sessions. And we will do that live, or we will do it later on in a reply to you if your question wasn't able to be raised. The first speaker today will be Andrei Michalik, who is a European patent attorney and partner at the firm. During the Q&A sessions, we will have two additional speakers besides myself. We will have Lisbeth Pamen and also Koen van Alst, who are both European patent attorneys. Koen van Alst also Belgian patent attorney, and they're also partners in the firm. So we hope you have been able to join, and I will now pass on the word to Andrei.
Hello, good day to everyone, wherever you are joining from. So we welcome you to this webinar, which we have named Getting Ready for Opt-outs. The reason, of course, for that is that that's perhaps most urgently on our minds. But of course, in order to address that issue, we also do need to know a bit of the context, and the context is indeed the European patent with unitary effect, or unitary patent, or UP, and the Unified Patent Court. So we will go through these. The UP and UPC are expected to start on the 1st of June, 2023. It's a system conceived for the European Union, but it is only joined by 17 out of the 27 EU member states for now. So if you talk about a system for European Union, perhaps it's useful to first look at what we actually talk about when we mention European Union. European Union has 27 member states. That's a fairly large population overall, 447 million. But of course, there are small states and large states. So the smallest population would be about 500,000, Malta, and the largest would be about 83 million, Germany. The median is about 9 million, which is approximately a country the size of Hungary. In terms of GDP, the EU overall has about $17.2 trillion. In average, that's 38.4 thousand per capita. But again, there are huge differences between the different states. The minimum in terms of overall GDP would be Malta, but the minimum in terms of per capita GDP would be Bulgaria, 11.7, while the maximum is, of course, Germany, the maximum per capita, which is 10 times higher than the minimum, is Luxembourg. If you then look at median between the different states, then overall it is approximately 281 billion, which is the country economy the size of Czech Republic, and in terms of per capita, 30.1K, which is approximately Spain. So this is European Union. When we talk about it, it is a union of quite a lot of states which are quite different. Of course, the EU does have a number of economic powerhouses. So if you just rank the states by their relative contribution to the overall GDP and this cumulative graph, you see that basically with the largest three states, Germany, France, and Italy, you already have reached 50% of the GDP, 50% of the European economy. If you then add 4 extra states, which basically is Spain, Netherlands, Poland, and Sweden, you're already reaching 3/4 of the European economy. And with 13 states, you're basically reaching 90%. So 1/2 of the states will reach 90% of the overall GDP. In terms of the patents situation which we have in Europe at present, essentially we have 2 layers, you could say. We have national patents and we have European or EP patents. National patents, of course, are require separate filings, separate examination where they are not automatically granted, separate grants, separate payment of annuities, and of course, a bunch of local agents. You also have to cope with different languages for the application documents as well as for the prosecution. And then we have a system, a second layer, which are the European or EP patents, which has been a very successful system. Currently, it involves 39 contracting states. These are essentially all of the 27 countries of the EU, and there are 12 non-EU countries in addition. So you have a map here where you can nicely see the coverage of the EPC. The European Patent Office centralizes the filing, the examination, the grant, as well as post-grant opposition. It only uses 3 EPO official languages: German, French, and English. You only need to pay single annuity before grant, and you only need a single agent. But of course, what happens after grant, once you have a granted European patent, it basically is a bundle of national rights. So what essentially happens is that this left side of the process is very neat. You have European patent application and central examination at the EPO leading to a grant. But afterwards, what you get is a bundle of EP patents in the 39 EPC contracting states, including the 27 EU states. This leads to, of course, a problem which has daunted the European patent system for a while, and that is the high cost and complexity of obtaining and maintaining EU-wide patent protection. So for example, for an EP patent, which is granted in English, if you would like to actually get protection in all of the EU countries, you would require 11 full translations of the patent, 9 claim set translations, and 21 local agents. Further, maintaining of EU-wide protection would then require the payment of annuities, which are certainly relatively high. So if you look at the left side, these are per year, and you see that basically for EU 27 in year 20, you're approximately at 20,000, and accumulatively, we are actually talking about a total cost of close to 170,000. If you then look at what actually you are getting, if you want an EU-wide protection and you're paying these annuities, in terms of total annuities per $1 billion of GDP, you see that there are huge variations between the different countries. In Germany, you basically pay about 3.3 euros, while in some of the smaller countries, you pay many, many times more. If you look at the EU as a whole, it's about 10. So it's 3 times higher than in Germany alone. And if you compare it to US for large or small entity, this is substantially higher than in the US. So per unit of economic size, you're essentially paying quite a lot in renewal fees. The second problem that exists in the European patent landscape is the high cost and complexity of EU-wide patent litigation. Basically, national courts typically decide on infringement and validity of respective EP national designations. This leads to parallel proceedings in several EU member states, which of course then requires you to coordinate multiple legal teams. It requires you to deal with a number of languages for the team members, for the submissions. And of course, there exists the possibility of conflicting judgments on infringement and validity. In terms of the enforcement, the extent of protection is harmonized by the EPC. Grounds for revocation also by the EPC. Rights and limitations are also largely harmonized in national laws, but of course differences do remain. So the laws may differ in, for example, things like the scope of research exemption, the scope of plural exemption. Case law may be different, which the courts rely on. For example, in terms of equivalent infringement. The experience and specialization of the judges can be quite variable. The procedural rules will be different between different countries. And of course, the different countries will have different legal traditions. So of course, there was the effort to find some solutions. And the solution to the problem number one, to the cost and complexity of getting EU-wide patent protection, has become the European patent with unitary effect, which for simplicity is also called unitary patent or UP. Currently, 17 out of the 27 EU member states are on board. Now, this already covers about 66% of the EU population and almost 80% of the EU GDP. So even though 17 out of 27 may not seem high enough, it actually does cover quite a large chunk of the Europe's economy. In terms of the solution to problem number two, the answer there will be the Unified Patent Court. So what has been created or will be created is a supranational court, which is common to contracting member states, which will have exclusive competence for actions regarding infringement and validity of EP and unitary patents and SPCs based on these patents in the contracting member states. Decisions for EP patents, so for the bundle patents, will cover the territory of the contracting member states in which the patent has effect. There will be one set of provisions on rights, limitations, and remedies provided by a Unified Patent Court agreement, one set of procedural rules. But all of this has become quite complicated by the provision of a 7 or up to 14-year transitional period, which we'll come back to. So turning to unitary patents, this is how it will essentially look like. You'll still have the very same procedure pre-grant. You will have a European patent application. You will have a central examination at the EPO and grant by the EPO. But afterwards, you can choose for a unitary patent in a subgroup of EU states instead of the EP bundles patent in those states. This unitary patent will have unitary effect in member states which have ratified the UPCA. It will require only a single renewal fee. There will be only a single translation necessary when requesting it. And the litigation will be before the Unified Patent Court. This slide basically summarizes the legal basis for the system, and perhaps the most interesting there are the regulations on the creation of unitary patent protection and the regulation on applicable translation arrangements. It's important to remember that unitary patents is not an obligation, it will remain an option. So the applicant may pursue a national patent, he can pursue a classical European patent, or for example, only unitary patent, or a combination of a unitary patent and classical EP patent in one or more non-UP EPC states. In terms of the effects of a unitary patent, so there will be unitary effect and uniform protection. It will apply provided that the unitary effect has been registered, which embodies indeed that it is an optional thing. The European patent will have a unitary character and provide for uniform protection. Because it has a unitary character, it can only be limited, transferred, or revoked, or may lapse in respect of all of the participating member states. It may be licensed in respect of the whole or part of the territories of the participating member states. The scope of the rights and limitations afforded by the unitary patent shall be uniform in all of the participating member states in which the patent has unitary effect. And the acts against which the patent provides protection will be those defined by the law applied to European patents with unitary effect in the participating member state whose national law is applicable to the European patent with unitary effect as an object of property in accordance with Article 7 of the regulation. And this is a relatively long way of saying that eventually the scope of the rights and limitations will be determined by the Unified Patent Court agreement, which has been ratified by that participating member state. Which states do participate? So in order to create this unitary patent system, there was an enhanced cooperation between a subgroup of EU member states. There were 25 of the 27 EU states which participated in the enhanced cooperation. It excluded Spain, which had objections, and it excluded Croatia, which became part of the EU later. However, the Article 18 of the regulation says that a European patent for which unitary effect is registered shall have unitary effect only in those participating member states in which the Unified Patent Court has exclusive jurisdiction with regard to European patents with unitary effect at the date of registration. In other words, unitary effect will only be present in those member states that have ratified the Unitary Patent Court agreement. So if you essentially look at a situation with respect to a particular EP patent that is granted after the system starts operating, you can divide the participating member states into groups. So out of the 25 states, there will be states that have ratified the UPCA by the date of registration of the unitary effect for this patent. And in those states, the patent will have unitary effect. And there will be states which have not yet ratified the UPCA by the date of registration of the unitary effect for that patent. And in those states, the patent will not have any unitary effect. So essentially what you will get are successive generations of UP patents, which will cover increasingly larger group of participating member states. That, of course, on assumption that some of the remaining states which have participated in the enhanced cooperation will actually ratify the UPCA. Once a later ratification does not mean that suddenly that country somehow becomes part of your earlier UP. There will really be successive generations of UP patents with different country lists. What is the expected situation and at the start of the UP system? So 17 states have ratified UPCA. There is a list and there is also the map. So these would be the blue countries. 7 states have signed but have not yet ratified the UPCA. That would be the light blue or light striped blue countries. And Poland actually has decided to not sign the UPCA. So perhaps if you see this, you will see that in terms of Western Europe, quite a lot of it is covered. Also in terms of the Nordic countries and the Baltic countries, the Spain is out, and the Central European countries at this moment, with the exception perhaps of Bulgaria, are not really participating yet. What about the timing? The UP regime enters into force when UPC agreement enters into force. Now, UPCA enters into force once at least 13 participating member states, including Germany, France, and Italy, have ratified UPCA. Germany has ratified and will deposit the ratification once the UPC preparations are sufficiently advanced. So Germany is basically acting as a kind of gatekeeper to be able to start a system once it is ready for use. The UPC enters into force on the first day of the fourth month after the month in which the last ratification required by the UPCA is deposited. Currently, the start of the system is expected on 1st of June, 2023. And importantly, unitary effect can be requested only for European patents granted on or after the UPC entry into force. Now, of course, if you hear that, then you realize that this is still about 6 months to go. And if you are now faced with an application which is perhaps close to grant, and you would like to actually have unitary effect for that application, then you do need to consider how to make sure that the grant of that application will not happen before the system starts, because then you would actually fall outside. For this reason, the EPO has adopted some transitional measures in order to facilitate adoption of the system. They will apply from the 1st of January 2023. We are quite lucky that the EPO has kept the date the same despite a delay in the start of the UPC. Applicant can request a delay in issuing the decision to grant. So if you get your intention to grant communication, but you have not yet responded to it, you can then request a delay in issuing the decision to grant. And the patent will then be granted on or immediately after the date of entry into force of the UPCA. The applicants, if they want to, can also file early requests for unitary effect, also in cases where the intention to grant communication has been received, in which case the EPO will register the unitary effect once the unitary patent system has started, of course, if the request actually complies with all of the requirements. So if you, for example, are dealing now with a European patent application and wondering, what do I want to do? Then you can ask yourself, do I desire protection in one or more EPC state covered by the unitary patent? There is the list of those. If you say, well, I actually don't, I, for example, just want protection in the UK, then you can perfectly proceed to grant and validate in the individual non-UP space EPC states. If on the other hand, you do desire unitary patent in there, if you do desire protection in one or more states that are covered by the unitary patent, then you can ask yourself the question, do I actually desire a unitary patent? Of course, if you say no, then you can just proceed to grants and validate in the individual UPC space, EPC states, and if you want to, also in some of the non-UPC, non-UP space EPC states. If you do want a unitary patent, then you can ask yourself, have I actually received an intention to grant? If you have not yet received it, the chances are that you might not actually be, receiving it anytime soon, and that your grant will be well after the 1st of June 2023, in which case you can request the unitary effect after the future grant. If you have received it, or you will receive it very shortly, You can ask yourself, well, is the deadline to respond before 1st of January 2023? I mean, that's not a lot of time left, so this box will become less relevant. If it is so, you may consider to delay grant. For example, by further processing, by not responding and responding later on, or by disapproving a text, which then wins you some more time. If the deadline is on or after the 1st of January 2023, you can then ask the EPO to delay the grant. You have to do that before you actually reply to the intention to grant communication. Optionally, you can file an early request for a unitary patent. And if the deadline is already after the 1st of June 2023, then you will anyway fall within the system unless there is a further delay, in which case you can request the unitary effect after the application grants. How do you register a unitary effect? So essentially you have 1 month after grant to apply for unitary effect at the EPO. Importantly, the patent must have the same claims for all 25 participating member states in the enhanced cooperation. So this is not limited to the 17. The same claims requirement applies to the 25. There is no administrative fee. There is only a single translation required, and this only during a transitional period of 6 to 12 years. And a renewal fee needs to be paid to the EPO after grant. In terms of the translation, the request for unitary patent has to be done in the EPO language of proceedings, but of course with trilingual forms, that doesn't constitute any problem. No translation is in principle required, but there is indeed a 6 plus potentially 6 extra years transitional period when one full translation without any legal effect will need to be provided. There are these requirements. If the patent is in English, you have to translate into any EU language. If the patent is in German or French, you need to translate into English. Of course, you can consider what to do there. For example, you could consider, do I want to use Spanish? I might be I might be actually considering a validation in Spain, since this is a large country. Also, Spanish text may often be available from countries like Mexico and Argentina and Colombia, which then means that its adaptation will be less costly than translating into another language, the complete specification. You could possibly, if you filed your priority application in an EU language, you could possibly also rework that to actually use as the translation. Importantly, the recital of the regulation on the translation requirements actually talks that the translation should not be carried out by automated means, and their high quality should contribute to the training of translation engines by the EPO. So even though, you might wonder, can I actually file a translation, which is a machine translation? At least the recital would suggest that a human translation should be intended. Now, of course, this regulation, you have to remember, they were agreed on 10 years ago. So, of course, in the meantime, the quality of the automatic translation means has become immensely higher. But this is nevertheless the transitional period that we do have to live with. In terms of representation, the EPO regime will apply. So proprietors from EPC states, both UP and non-UP states, will not need to be represented. Proprietors from non-EPC states will need to be represented. This is a separate proceeding, so in principle you need separate authorization or general authorization for the UP proceedings at the EPO. But the system in which the European patent attorneys are normally exempted from submitting authorizations unless there are reasons to ask for one will also apply. So this is a slide which essentially shows that if everything goes well, so if you file your request in 1 month period, if the patent contains same claims for all participating member states, and if you have complied with all of the formal requirements and have provided translation, the EPO will proceed to register the unitary effects, and you will be in the left side of the slide, which means that actually everything is good and the procedure has run very smoothly and easily. Of course, things can happen in which basically some of the requirements are not met. And in that case, there are procedures foreseen in addressing this. There may be invitations to comment or to remedy certain deficiencies, and the requests can be afterwards either granted or eventually rejected. Now, once the request is rejected, the UPC actually has the power to look whether the decision of the EPO was correct or not. What about the costs? So, of course, since this is basically a post-grant choice, there is no change in pre-grant costs. So you will have a European application, will be centrally examined and EPO and granted. All of those costs will remain the same as so far. Of course, the change will come after grant, which where in one case you would be going for individual validations in the UP countries, while in the other case you would be going for the unitary patent. The renewal fees for unitary patent are perhaps the most relevant part of those costs. There will be a single renewal fee, which will be based on the sum of national fees in the top 4 EPC countries. There will be a 15% reduction in renewal fees available for proprietors who file a statement on a license of right with the EPO. Here is actually a table which lists those fees. And you will see there is a bit of representation, since numbers are not always that easy to understand immediately. But if you look at this, on the left side you have the annuity, on the right side you have the cumulative UP annuity. So you will see that it is progressive from 35 euros in year 2 to almost 5,000 euros in year 20. And the overall cost, if you will be paying for the full 20-year term, is about 35,555 euros. Now, importantly, it's a progressive fee, and it progresses in a nice way because the first 50% of the patent term, so years to 110, will only cost 13% of the overall cost, about 5,000 euros. So, of course, with a view to the fact that a lot of European patents are not kept for the full 20 years of their term, are allowed to lapse somewhere in between there. The fact that for the first 1 to 10 years, you only pay 13% of the overall cost is quite attractive. For the first 75% of the patent term, you would actually pay less than half of the overall cost. So if you compare the annuities for the unitary patents to the annuities for the individual countries, essentially this graph shows you what the annuity would be for 1 country or for 2 countries or 3 countries and so forth, up to 17 countries. And essentially this has been calculated by summing the countries once they have been ranked in the order of their GDP, from highest GDP to lowest GDP. So you will nicely see that, for example, if you are talking about Germany, which would be the country 1, or Germany and France, or Germany, France, Italy, then you would be lower with the 3 renewal fees when paid to the national patent offices than with the UP renewal fee, which is the red dotted line. But once we actually start talking about 4 countries, then you're coming to approximately the same amount. And of course, if you would then be validating in more of the UP 17 countries, then those costs would be a lot higher than the UP cost. If you would look at some common strategies versus the UP, so for example, if you would just validate in Germany, it's clearly cheaper. If you, as I said, Germany, France, and Netherlands are still cheaper. If you would, for example, go for Germany, France, and Benelux, then this is approximately the same as the UP renewal fees. And of course, if you then add Nordic countries or Italy, or Nordic countries and Italy, then the UP is already considerably cheaper in terms of the renewal fees. If you look at the total annuities relative to the size of the economy, so this is a graph you have seen before. You see that, you know, Germany was relatively attractive at 3.3 euros per billion of GDP, while some of the smaller countries were relatively a lot more expensive, and EU was at 10. Then you see that the UP comes at approximately 2.7. So it is approximately in the vicinity of Germany, France, and Italy. It is still higher than the US, but it is already a lot closer to countries which have very performant and large economies within the EU. One important thing to remember is that this is a unitary right, it's a unitary patent, and that's why a lapse is only possible for all of the states where the patent has unitary effect. So what you cannot do are optimization strategies as illustrated below. So for example, with a green line where you would start in 5 countries and then at year 10 would decide, well, perhaps it's enough to keep the patent in 2 countries. So you stop paying renewal fees for 3 of those countries. And then in year 15, you would decide that even keeping it in 1 country is enough. That you could do if you have the classically validated European bundle patent. You cannot do this with a unitary patent. So with a unitary patent, as long as you're still interested in protection in at least one of the countries covered by the UP, you will have to pay the full UP fee, and you will then, of course, keep the protection of the 17 countries. Of course, annuities are not the only thing that matters. So there are also other costs. For unitary patent, as I said, you need only 1 translation of the whole patent during the transitional period of 6 or maximum 12 years. You need only 1 agent fee to request registration of unitary effect and no official fee. And you need only 1 agent fee to pay a single UP annuity each year. In contrast, if you would take the EP bundle patent in the UP 17 countries, you will need a number of translations depending on the local provisions. You may need to only translate claims, or you may need to translate a whole specification. You may need agent fees for each state which requires a translation, and agent fees to pay the annuities in each state each year. So for example, if you take a European patent granted in English, and then you again make this kind of ranking of the countries by their GDP, so Germany, France, Italy, and so forth. Then on the right side, you can see what cumulative translation requirements and local agent requirements you will be looking at. So you will see that, for example, for like the, for the Germany, France, Italy combination, you will need 1 whole patent translation and 1 local agent. But of course, if you go down in that table, you will end up with all of the 17 countries where you need 7 claim translations, 5 whole patent translations, and 12 local agents. So to illustrate it in some common strategies in terms of the cost, then Germany would, for example, the UP would cost you additional amount in the total annuities, and you would need 1 more full translation compared if you validate it only in Germany, which does not require any translation. Germany and France, again, you would be paying more for the annuities, and you would still need 1 more full translation compared to the individual validations. For Germany, France, and Belgium, you're still paying more with the UP, and you still need one more translation than you would otherwise need. With Germany, France, Belgium, and Netherlands, you're coming approximately at the same level in terms of renewal fees. And you will still, with UP, will need one extra full translation, but one less claims translation and one less local agent. And if you then also add Italy, then you're already coming to a cheaper situation with the UP. You will need the same number of full translations because, of course, in Italy, you need a full translation, and in UP, you need a full translation, but one less claims translation because Netherlands, you don't need to translate in the UP, and two less local agents. So you will see that at approximately this 4 or 5 country level, it starts to be attractive in terms of both the NUT fees and the number of translations and local agents. And of course, not to forget, the UP will give you the protection in the additional states of the UP17 group. There is also perhaps something to remember, which we might not have time to really go into, and that is how unitary patent is handled as an object of property. So of course, it is a unitary right. It has a unitary character, and therefore it is handled as an object of property or treated as an object of property in its entirety and in all participating member states as a national patent of the participating member state in which certain conditions apply. And actually you have it here. It's either the state which had where the applicant had his residence or principal place of business on the date of filing, or at least the place of business. And what is interesting is, of course, that when there are 2 or more persons that are actually entered as joint applicants, then the paragraphs are applicable to the applicants in the order they're mentioned. So to the joint applicant, which is indicated first. If essentially these criteria cannot be applied to any of the applicants, then the patent as object of property will be treated in accordance with German law. So this can be, of course, quite important and relevant for issues such as licensing and joint ownership. And indeed, that's why perhaps you do need to give a thought, even for applications which you are preparing and filing now, to the order of the applicants on the application, such that you can ensure that certain national law applies to the later unitary patent as object of property, if it is ever requested as unitary patent. You can also have the possibility to indicate at least a place of business together with the request for unitary effect. So to summarize the key features of the unitary patent, patent prosecution will be before the European Patent Office. It will just remain as it is. After grant, there will be an option to, let's call it, validate as one unitary patent. There will be a single maintenance fee, limited translation requirements, and it will only apply to the participating member states which have ratified the UPCA agreement. The unitary patent will always remain optional. It is not possible to step in later, and it is not possible to step out after having stepped in. It will be one patent in all participating member states that have ratified the UPCA, which means that a lapse, a renewal fee, non-payment, revocation, or limitation is only possible for all the states. And it will always be enforced through the Unified Patent Court. So the factors that you could consider when deciding on UP and your validation strategy is, of course, the desired territorial scope. Is the territory covered by the UP interesting for you? Is it perhaps enough? Do you need other validations? Another factor, of course, will be costs. Are they comparable, lower or higher for the desired territory that you need? Have you been validating in a limited territory before because of the cost only, or have you been validating in limited territory because of other reasons? It is not possible to downsize a unitary patent, as I said. The administrative burden can be considered. This is a single request and single translation and payment of a renewal fee to a single institution, the EPO. You will have to keep in mind that indeed the competent court for infringement of validity for UPs will be the Unified Patent Court. You can consider the patent strength. Are you worried about the risk of revocation before the UPC, or is the patent strong in your view, such that you are basically confident it will survive even an attack before the UPC? Is there a risk of national prior rights? Can you accept the less flexibility in transfers, and since you can only transfer the unitary patent for all of the states which it covers? Are you fine with the applicable law on rights and limitations, which will be UPCA? So perhaps it may have some advantages in terms of process claim infringement or contributory infringement within that broader territory. Scope of the exemptions may be affected. Perhaps the exemptions defined by the UPCA may be narrower than exemptions for that are defined in some individual countries. You will have to consider indeed the applicable law on the patent as object of property, so it will not be country by country. It will all be governed by one law. Will the UP be attractive to investors, to future licenses, to partners? And indeed, you should also not forget that the exclusive licensee has in principle the right to start UPC infringement proceedings after having notified the proprietor. So this would be basically everything I wanted to take you through on the unitary patent part. So now there will be approximately 10 minutes or so for a question and answer session with my colleagues.
Hello. Yes, thank you, Andre, for this nice presentation. So I'm actually going to present you a question that was asked by someone. So a question came about the transitional measures that the EPO has in place to get into the unitary patent system. And the question was whether it means that the two transitional measures, so the delay, requesting the delay in the grant and requesting the unitary effect, have to be actually taken together. And I think personally that the reply to those questions, that question is that they are actually separate procedural measures, which can be taken separately, but also depending on the case, you could decide to take both of them. So the one which is called the early request for unitary effect has to do with the fact that as from 1st of January, you will be allowed to ask for a unitary effect, so that as from the date of, for example, 1st of June or after that date, your patent would then have a unitary effect as from the date it is granted. Depending on the case on which day you ask that earlier effect, and also both of these measures, don't forget, require that there is a pending Rule 71.3 communication. So depending on the date, you might also wish to combine it with a delay to issue the grant, because then your grant will be issued as soon as the UP effect is possible. And also you will have declared an early effect, which has the benefit that when your grant comes out, the patent is already in a unitary effect or very soon afterwards. So this can have its benefits. Maybe someone else wants to treat of the panelists another question that came in.
Okay, so I have another question that came in regarding national prior rights. So I think Andre already touched on that a little bit in the slides. So the question goes like this. If I have a published Belgian national granted patent that was also a prior right for my European patent application, will its influence on a corresponding European patent be different if I request unitary effect or not? And the question is yes, of course. So the problem with the unitary effect is that you cannot really have different claims anymore for different member states of the unitary patent system. That means that if you have a national prior right, so a publication from a patent that has a filing date prior to yours, but a publication date later than the filing date, so it was not full prior art, but some secret prior art, if you like, then it might be detrimental only for the national, for that national chapter, let's say, of the European patent. So in this case, if you have a Belgian validation of a European patent, that part might not be new over a Belgian national granted patent. That is a prior right. That's the situation we have today. But if you have unitary effect, then there's a problem because you would have to change claims in Belgium, which is not possible. So in this case, you would have to limit the claims throughout the whole unitary patent group of states instead of only this one. And to make sure that this doesn't surprise you, the EPO is also starting with some kind of top-up search. So prior to issuing the intention to grant, they will provide you with a search report directed to these specific national patents or patent applications, such that you are aware of potential risks on that.
Thanks.
All right. There are more questions, but I think there are many more on opt-outs, so we should probably leave those until after the second part. There is one short question on that we can maybe still answer. Would the claims continue to be translated in the 2 other EPC languages for unitary patents and before the grant is announced? And yes, that's definitely the case. You still have to file the translation of the claims in response to your Rule 71.3 communication. So that's independent of whether or not you request a patent with unitary effect or not. All right, so I think it's more efficient that we continue with the second part, given the number of questions on opt-outs, and I leave the word to Andre again.
Thank you very much. I'll try to move the slide. All right, there we go. So turning to Unified Patent Court, which you'll recall was the solution to the problem number 2, the problem of fragmented litigation, patent litigation in Europe. Unified Patent Court will be a supranational court, which is established by the Unified Patent Court Agreement. It's a court common to the UPCA contracting member states, and it's subject to the same obligations under EU law as any national court. It will apply to, so the agreement will apply to unitary patents, to European patents that have not yet lapsed at the date of UPCA entry into force or are subsequently granted, to EP applications pending at the date of the UPCA entry into force or ones which are subsequently filed, and to supplementary protection certificates based on EP and UP patents. So you clearly see that the intention is not to create the system for things which are filed in the future. The intention is indeed that the patents and pending applications, patents in force and pending applications will also fall within that agreement. It will establish one court. It will have competence for most questions of patent infringement and validity. The agreement contains one set of substantive provisions on rights, limitations, and remedies. There will be one set of procedure law enshrined in the rules of procedure, and one decision directly enforceable in all UPC contracting member states. And the decisions for EP patents, for classical bundle patents, will cover the territory of the contracting member states in which the patent has effect. In other words, the idea is that you ask one question, you get one answer, and you may or may not like it. The Unified Patent Court will apply a hierarchy of applicable law, starting with relevant EU law, unitary patent regulations, of course, the Biotech Directive, IP Enforcement Directive, SPC regulations. Further, the Unified Patent Court Agreement, which contains the substantive provisions on rights and limitations and remedies. It will apply EPC, which defines the extent of protection and grounds for revocation. It will also apply international agreements, which are binding for all of the contracting member states, and national law, where that is applicable. This is a relatively long slide, but there is a list that enumerates the exclusive competences of the court. So it will have exclusive competence for actual or threatened infringements of patents and SPCs, for declarations of non-infringement, for provisional and protective measures and injunction, for revocations or declarations of invalidity of SPCs, as well as counterclaims for revocations and invalidity of SPCs, actions for damages and compensation derived from provisional protection, rights based on prior use of the invention, and then also actions for compensations for licenses, and importantly, for the review of the decisions of the European Patent Office when carrying out the tasks related to registering the UP, the unitary effect. So the UPC has exclusive competence with respect to these actions for both the UP and classical EP patents, but a transitional period has been foreseen, which provides 7 plus potentially 7 extra year window of parallel UPC and national courts competence for classical European patents, and the same 7 plus 7 year window to opt out classical European patents and EP applications from UPC's competence for their remaining lifetime, unless the proprietor decides to later withdraw the opt-out. Importantly, it is also clear by the interpretative note that only national courts will be competent for opt-out EPs and will apply the national law and not the UPCA. Importantly, it does need to be stressed, there are no opt-outs for unitary patents. The unitary patents are within the exclusive competence of the UPC. So essentially, this leads to competence during the transitional periods, which looks approximately like follows. So of course, national patents have no unitary effect and fall within the competence of national courts. EP patents, classical patents which are not opted out, also don't have any unitary effect, but may fall within the competence of either UPC or national courts. So there is a parallel jurisdictions on these. EP patent, which is opted out, also has no unitary effect and will fall within the competence of national courts. And a unitary patent does have a unitary effect and falls within exclusive competence of the Unified Patent Court. After the transitional period, basically the main thing that essentially changes is that a classical EP patent, which has not been opted out during the transitional period, will then be falling within the exclusive competence of the Unified Patent Court, while the European patents which have been opted out during the transitional period will continue to only be litigated before the national courts. So of course, what this means, if you count 7 plus 7 years, so applications filed close to the end of the transitional period and published, in time for the opt-out to be requested, essentially can be requested for their whole lifetime. And of course, there may be SPCs on patents which result from those applications. So essentially what this means is that national courts in the UPC contracting member states will be dealing with EP and EP-based SPC related actions, which in the absence of a transitional period would have fallen within the exclusive competence of the UPC for the next 35 to 40 years. The window of the parallel UPC national courts competence for EPs will also lead to questions of jurisdictions, which basically is the reason why I included this tangle of virus in the picture. But those questions would definitely be of very much interest to many lawyers, and of course the court will need to resolve these questions. In terms of the UPCA territory applications, you've seen this slide pretty much. So again, we are talking about the 17 countries, the expected situation at the opening of the UPC, and the 7 states which have signed but not yet ratified UPCA are in light blue. So in terms of UPCA entry into force, Germany has ratified and will deposit the ratification once the UPC preparations are sufficiently advanced. Originally, it was foreseen that the system could perhaps start on 1st of April. Due to some technical issues, it was delayed by 2 months. So now it is expected to start on the 1st of June. And it will be preceded by a sunrise period, which is expected to be, let's say, commencing on the 1st of March and will end on 31st of May. And during that sunrise period, the requests for opt-outs can be filed with the UPC registry. The opt-out applications that are accepted during the sunrise period will be treated as entered on the register on the date of UPCA entry into force. So basically on the 1st of June. You can also start filing requests for European patent attorneys with appropriate qualifications to become representative before UPC. So just perhaps on this point, I don't think I have a lot of elaboration on this point, but basically parties will need to be represented in most proceedings before the UPC, and they can be represented by lawyers from contracting member states or by European patent attorneys who have appropriate qualifications. And the appropriate qualification would typically be a European patent litigation certificates, which are not yet being issued, but there will be a grandfather possibility for a number of European patent attorneys who have followed certain specified courses and who will then be able to get that recognized as the appropriate qualifications. So the important point is European patent attorneys will be able to actually represent clients before the UPC. In terms of the structure of the Unified Patent Court, it is a one court, but is somewhat decentralized with divisions throughout Europe. So there will be a central division in Paris, a branch in Munich. There will be local divisions in a number of countries, most countries just one. In Germany, because of the volume of cases, which it normally sees, there will be 4 local divisions. There will be 1 regional division, which is basically for the Nordic and the Baltic states. What is interesting in terms of composition of the panels, which actually look at the case, so there will be legally qualified judges, but there will also be technically qualified judges. So central division will always contain a combination of 2 legally and 1 technical qualified judge. In local divisions, the panel will be 3 legally qualified judges, which can be supplemented with a technically qualified judge if there is a counterclaim for revocation or if the parties actually request that. It's similar to in the regional divisions as well. It can also be heard by 1 legally qualified judge if the parties agree. The Court of Appeal, which will be in Luxembourg, will have 3 legally qualified judges and 2 technically qualified judges. The UPCA and rules of procedure, they contain detailed provisions on competencies of the divisions for the different types of action. And also provisions on languages that are used in the proceedings, but it's interesting to know that English will be available in most divisions, also in Belgium. It can happen that infringement and validity might not be handled before the same division, that perhaps infringement will be dealt with by local and regional division, while the revocation will be referred to the central division. But at least many commentators think that this may be rare because the judges may be motivated to perhaps see or hear both parts of the case. So in terms of the pros and cons and features of the Unified Patent Court. We are clearly talking about proceedings before a single court. So there would be avoiding of costs of parallel litigation in several jurisdictions, which of course brings the cost of different legal teams, the coordination between all these teams, the cost of translations. So this is the main advantage proceedings before a single court. The decisions will cover the whole territory of the UPCA contracting member states for unitary patents and the territory of those UPCA contracting member states in which the patent has effect. So basically, you'll be getting centralized enforcement, but also possibly centralized revocation. Substantive provisions on rights, limitations, and remedies are harmonized by the UPCA. So there is basically, these provisions are in the UPCA and they will be interpreted by the court. The case law developed by national courts may thus not be followed. It will contain a completely new set of procedural rules. So it may also mean that perhaps there will be flexibility and pragmatism in shaping the procedure towards the future, which might, of course, also be one reason to perhaps participate at least with something so that one is actually part of the shaping of the court and its procedure. Of course, there will be early unfamiliarity with the procedure among the users, which combined with short deadlines is, of course, a challenge. What is definitely interesting is that the court is basically involving really experienced, specialized patent judges, including technically qualified judges. So, of course, you will have less exposure to judges without adequate expertise in patent cases. Of course, it also perhaps means that judges may more readily see through weak evidence and arguments. There will be multinational panels of judges, so the system is designed such that for some of the larger countries, there may be two judges who are nationals of that country and one judge that is not. It's for some of the smaller countries, or let's put it small, the local divisions in the smaller countries, where there is perhaps less experience with dealing with patent cases, there may be one national of that country and two judges who are nationals of other countries. So there will be deliberate efforts to minimize the impact of national legal traditions. Of course, the downside perhaps is that unlike judges in national in the individual states, the judges may actually not understand the language of proceedings without interpretation. The speed of decision is a feature which is pronounced a lot and it's considered attractive, of course, if actually the caseload is such that it can be complied with. So first instance decisions are expected within about a year. It's a very front-loaded procedure in terms of evidence and arguments. And there is really a merciless sequence of very tight deadlines. So that is very much a downside of that, because with deadlines of 2 months and similar to prepare a case when it is served just before the vacation period, that may definitely not be an easy thing to do. Costs, probably there may be lower than parallel enforcement in multiple jurisdictions. Maybe also perhaps lower than parallel revocations or declaration of non-infringement actions in multiple jurisdictions. There is typically a fixed fee, and then there may be a value-based fee depending on the value of the case. It does provide a second shot at centralized revocation of a patent next to EPO opposition proceedings. It's probably faster than EPO opposition proceedings, even though the UPC may also ask the EPO to speed up. But it also will probably be more costly because of the basic fee for revocation, which is already 20,000 euros. But on the other hand, there is recovery of lawyers' fees, where at the EPO, normally every party pays its own costs. And of course, there is a risk of infringement counterclaim if you do file centralized revocation at the UPC. Whether it is possible to file strawman revocations at the UPC is not entirely clear. based on the language of the statute. If you decide to opt out, so if this advantage and disadvantages have given them a thought and you then after all decide to opt out, let us keep in mind some issues. So first of all, unitary patents always are within the competence of the UPC, which also means that opt-out is not available for unitary patents. Opt-outs will also not be possible if an action has already been brought before the UPC. All actual applicants or proprietors must lodge the opt-out. So basically, these are the applicants who own the proprietors who own the patents, irrespective of whether they are registered or they are not registered in the National Patent Register where they own the patent. Declaration is needed that the proprietors are entitled to be recorded in National EPO or EPO registered if they are different from those recorded. It seems that if you look at the documents which the UPC has provided as templates, there is a default declaration which simply states that the person who is lodging the opt-out also confirms that indeed all of the proprietors mentioned are entitled to be recorded in the National Patent Registers. The application to opt-out must be lodged in respect of all states for which the EP has been granted, which have been designated in the EP application, in case of applications. So this is quite an important requirement because, of course, it just says in the rules of procedure for the states for which EP has been granted doesn't really say much what happens with the EP in the various states afterwards. The opt-out will extend to SPCs, which are based on the EP patent. But if the SPC holder are different from the patent proprietors, they also must lodge the opt-out together. For later granted SPC, the opt-out, the earlier opt-out of the patent automatically takes effect. The applicant or patentee may withdraw opt-out later. So you could say, well, it is a relatively attractive thing. I could opt out, which keeps everything as it normally is. And then if I see that the system operates, or if I am interested in wider enforcement, I could perhaps opt in and still use the benefits of the system in terms of the wider enforcement. But there is a condition, and that is that unless an action has already been brought before a national court. So the action, and of course there may be discussion of what the action must be or what type of action, may lock the patentee out of the UPC system. The rules of representation do not apply for opt-outs. So they can be performed by the proprietors, or the proprietors can actually mandate anyone to perform the opt-out. And even while there may be some discussion about this, also during the sunrise period, the belief is that the representatives who will be registered according to Article 48 UPCA can also perform the opt-out. After the 7+7 transitional period, years of transitional period, no opt-outs will be possible anymore. So essentially at that point, only the patents earlier opted out or the applications earlier opted out during the transitional period will stay out of the system. There will be a sunrise period, as I said, from 1st of March to 31st of May for opting out. And importantly, the effective date of opt-out is the date of entry in the UPC register. So the sunrise opt-outs need to be performed well before the 1st of June, start of the system. So to conclude, in terms of practical action points at this stage, do need to consider your general user or industry profile, what the costs are, the risks, patent environment. Review your patent portfolio as owner or as a licensee. Envisage what litigation strategies could be applied from both sides. Consider the impact of the UPC or national court competence to guide the opt-out versus stay-in decisions. Consider on that basis whether you actually wish to apply for opt-outs during the sunrise period and for which of your patents or patent applications. Review ongoing projects also for the future, for example, for things like order of applicants, right to decide on unitary patents, right to decide on opt-outs. Review your existing contracts, collaborations, co-ownerships, licenses, indeed, about who may influence decisions of this type, and as well adapt your template for future contracts. So I think this brings us to the Q&A session number 2, which Lisbeth already has foreshadowed will contain quite some questions on the opt-outs.
All right, thank you, Andre. I think, Kun, you were going to start with a question?
Yeah, thanks, Lisbeth. So I'm actually going to combine 2 questions which are more or less on the same topic. So we're getting into the strategic insights here regarding whether or not opt out. Maybe just before I dig into the question, I think the unitary patent system as it currently stands can be a very attractive system for some applicants for some cases. It can also be somewhat dangerous for other cases. So it really depends a bit on the type of IP portfolio you have and on what your goal is. Is it more defensive? Is it more offensive? And so on. The question here kind of deals with that aspect. So the question is as follows. I have a European patent validated only in Belgium in this case, so it could be in a single country indeed. Should I request an opt-out, and what would be the reasons to request for an opt-out? So this is an already granted patent, only validated in Belgium or only still in force in Belgium. Is there a reason to opt out? Well, in fact, there is a reason, not so much because you are going to litigate yourself, but there might be a risk that somebody is annoyed by your patent and tries to invalidate it. If you do opt out, you kind of keep control of what to do in case of invalidation action. If you do not opt out, the third party who may be annoyed by your patent, who might just try to annoy you as a company, as a competitor, could launch an invalidity case before the Unitary Patent Court, which might end up in high litigation costs. Especially something to keep in mind is that before the Unitary Patent Court, they have the loser pays system, which means that you will also be liable to paying the fees of not only the court case, but also of the lawyers, the litigators on the other side of the winning party. So if you run the risk of an invalidation suit before the Unitary Patent Court, you might end up at least in the several hundred thousands of euros in litigation costs that you need to pay for, let's say in this case, simply a European patent that is still only valid or in force in Belgium. So the risk there is actually much too high not to opt out. On the other hand, and that's the second question, if you have quite an extensive portfolio, but you're generally not involved in litigation, meaning you have a more defensive position rather than an offensive position. Should I then request opt-out? And what would be the reason to request such an opt-out? Well, in this case, again, you don't really have a lot of advantage in staying in this UPC system if you're not going to litigate yourself. The UPC system is very helpful for two reasons, basically. If you want to have a unitary effect, or European patent with unitary effect, because you want to cover as many countries as possible for as low as a price as possible, then this unitary effect is helpful. And of course, the Unitary Patent Court is linked to that. If you're really in a defensive state, and for granted patents or for European patents that have already been granted, then a safer way is to opt out, again, to avoid potential court costs or litigation costs in case you might lose an invalidity suit that is launched by a competitor. Lisbeth?
All right, thanks for that. I've been collecting a number of questions with regard to the opposition procedure. And so there's a first question that indicates I have a patent that's currently in opposition proceedings. Should I ask for an opt-out of this patent? If I don't, can the other party start proceedings before the UPC while the opposition proceeding is still running? Indeed, if you have not opted out your patent, there is the possibility for third parties to start a revocation action against your patent. So these procedures can run in parallel. There is the provision that the UPC can stay its proceedings if they think that a decision from the opposition division is imminent, but it's of course unclear how they will assess this, and it might have to do with the time period that the revocation is being filed, whether it's at the beginning or at the end. But of course, that will be up to the specific case at the time. And so that's with regard to the questions. You can have both proceedings at the same time. Another aspect of this opposition is, of course, as a third party, there are a number of questions. What are the advantages and disadvantages relating to opposition versus revocation? And of course, these are different and brought before different instances, and there's clearly a number of advantages and disadvantages to the UPC revocation action. That's now the new procedure that we're going to get. So one of the clear advantages is that you can do it after the opposition period, while for opposition you have those 9 months after grant that you can file opposition in, and that's it. But there are other advantages that have been raised, like the fact that you would get a quicker decision. There are time limits in this UPCA, so that they do expect that the actions will be quicker. And something that Koen touched upon before, the fact that you could use national prior rights to invalidate, or at least to get the limitation of the claims before the UPC. Of course, there are also disadvantages. It's expected to be more expensive. I think the opposition fee is around 900 euros now, while the official fee for revocation is, I believe, something like 20,000. So that's a start. But of course, that doesn't take into account all of the other fees, the costs that you will have. Another disadvantage is, of course, only for those UPC member states, the 17 states for now. So you will not have a revocation in the UK. If that's important for you, you need to take that into account. You also cannot, it's not clear whether you can be anonymous if you want to start the revocation action. You have to demonstrate that you are a party concerned with a patent. So that's more or less implies that you have to identify yourself. What may be an advantage or a disadvantage, depending on your point of view, is the fact that you have cross-examination of experts. So depending on how strong your experts are, that may be an advantage or maybe a disadvantage, or if you believe that the other party is going to have a lot of experts and you think that it may be useful to have cross-examination, that would be interesting to go through the UPC. What else did I jot down? The cost that the winning party can recover costs of the opposing party. So that's, of course, also adds on to the costs if you go for a revocation through the UPC. There is, yes, one of the advantages if you're after, in a period after the opposition has started, that you could, you're no longer limited to the arguments that are presented in the opposition, because of course opposition case is defined at its start, and so if at a later time point new arguments would come up that can't be brought before the EPO, because of course also very pertinent arguments can be brought in later in opposition. But if you would be in a situation where you would like to bring new arguments in, that then it may be interesting to start a revocation action separately. Did I touch everything? Yes, the possibility to argue lack of entitlement before the UPC is also something that you cannot do in opposition proceedings. So I think I more or less covered everything, unless Koen, you have anything to add on that or on?
Yeah, go ahead, Koen, please.
No,
If you
no,
want
I
to
don't
add,
have anything to add on this aspect. Should we? We're almost at the end. Should we try to do one more question?
Yeah.
Please do so.
So I have a more legal question regarding licensing agreements. So regarding the opt-out procedure, it's important to know that even an exclusive licensee does not have the right to opt out a granted European patent. So it's important for everybody that has licensing agreements running, whether you are the exclusive licensee or a licensee, or whether you are the proprietor, to go back and look in those contracts, let's say in those agreements, to see whether there is something mentioned regarding unitary patent court litigation or not. If not, you will probably have to negotiate or talk at least with the licensee or with the proprietor, because it's only the proprietor that can opt out. But of course, if there is in the agreement a clause that indicates that no rights can be lost or abandoned without the consent of the proprietor or the licensee, then of course this could be an issue that needs to be taken into account. So it's very important to have a look in existing licensing agreements to see who is in the driver's seat and who has control, and how that actually affects your possibility to opt out granted patents. Of course, for future licensing agreements, you will have to also take that up in a specific clause to make sure that it's clear who decides and who takes responsibility for that.
Thanks a lot, Koen, and thanks a lot, Lisbeth, and also Andre. I think somehow we've come to an end almost, and we have 2 minutes left. I think anyway, we want to thank you all for joining us. We have quite a lot of questions that are unanswered. We'll try to put an answer to the people who sent them. We'll also provide you with slides still. So we hope you enjoyed it, and it's certainly a topic to be continued on.
All right, bye-bye. Thank you.
So everyone have a very nice day still. Bye-bye.
Thank you very much. Bye-bye.
Bye-bye.